Among many state governors whose COVID-19 lockdowns have wrought economic destruction and seen massive uprisings among the residents, Michigan Governor Gretchen Whitmer might be one of the most despised. And now the Michigan Supreme Court has cast more light on her mind-blowing disregard for statute and constitutional rules, not just because of its recent ruling, but because the ruling has inspired her to double down and, get this, attempt to keep her lockdown powers going. Hi everyone, I'm Gardner Goldsmith for MRC-TV. Well, on Friday, October 2nd,
the Michigan Supreme Court, which has just ruled against Governor Whitmer in an emergency powers case. The court says the governor exceeded her powers during the pandemic, ruling that a majority of her executive orders after April 30th were not valid.
At issue were Whitmer's executive order commands that only certain businesses could be open, that people had to socially distance and wear masks, and her claim that she could keep those orders going and going despite Michigan statutes. The Daily Wire's Tim Pierce explains. The court ruled that Whitmer lacked authority under each of the two laws that govern states of emergency in Michigan to extend the state of emergency past April 30th, when her first state of emergency declaration expired. And on that statutory level, the pertinent laws were the 1945 Emergency Powers of the Governor Act, that's EPGA, upon which Whitmer attempted to stand, and the subsequent partial override of that act, the 1976 Emergency Management Act, or EMA. First, the court ruled 4-3 that the 1945 EPGA broke the Michigan Constitution by allowing the state legislature to delegate practical statutory authority to the executive branch, the branch which, of course, is only supposed to execute constitutional statutes, not issue diktats as Whitmer has. From the Michigan Supreme Court, we see this. Because the rest of the court interpreted the statute more broadly, Justice Viviano addressed the constitutional issue and joined Justice Markman's holding that the EPGA is an unconstitutional delegation of legislative power, which ought to be a message to Americans to apply the same standard to the federal government. But of course, it's unlikely that many public school teachers or pop media journalists out there will bother spreading that information about the difference between the executive branch and the legislative branch. Then there's the 76 statute, which placed a time limit on the already unconstitutional power that the 1945 EPGA created. As Beth Bauman writes for townhall.com, a separate law, the 1976 Emergency Management Act, also prevented Whitmer from extending her original shutdown orders without legislative approval. That means that the lockdowns should have expired on April 30th unless the state legislature decided to extend it. Of course, the lockdowns did not expire. Like the insufferable Oprah Book Club, they went on and on and on, seeing businesses shut down, gatherings on private property banned, seeing mask mandates even in private places, which Whitmer, of course, and many others mistakenly call public, even though they're privately owned, seeing Michigan Attorney General Dana Nessel charge a 77-year-old barber with criminal penalties merely for welcoming people into his shop to engage in peaceful commerce for services, and by June, seeing the state economy tank and its unemployment numbers the second worst in the nation. With the ruling, that barber, a man named Carl Mankey, who has become something of a folk hero in Michigan, is hoping to see the charges against him dropped. Of course, it's difficult to figure out how a rabidly leftist governor peddling in class envy and supposedly standing for the little guy can keep up her authoritarian charade. But Whitmer isn't backing down on her claim to power. Get this, Bauman points out that Whitmer has asked the Michigan Supreme Court to rehear this case, which her team of tax-fed autocrats argue buys her another 21 days to continue claiming her executive power authority to order people around and shut down their businesses anytime she likes. According to Detroit News, Whitmer has made the argument that her lockdown orders are good for another 21 days. That's the time period a governor has to obtain a rehearing from the state Supreme Court. She's like the ever-ready bunny of lockdown. She keeps going and going and going. What's curious about this whole situation, including the Michigan Supreme Court ruling that has exposed Whitmer as the Lady Macbeth of her state constitution, is that the Michigan court did not come close to discussing the overt and blatant insult to the U.S. Constitution that any and all so-called public health policing statutes represent. All lockdowns of businesses breach the contract clause of the U.S. Constitution, whether they're done through legislation or the executive branch. They also breach the First Amendment's protection of the right to assembly, the Fourth Amendment's prohibition to unwarranted searches and seizures, the Fifth Amendment's prohibition against property takings without so-called just compensation, the Fifth Amendment promise of due process, the Sixth Amendment promise of a fair and speedy trial before a jury, the Eighth Amendment prohibition against cruel and unusual punishment. As I've noted in previous pieces and in previous videos on lockdowns, there can be no punishment if there has been no trial, and a lockdown is the obvious act of taking away a livelihood, which is punishment. And it breaches the 14th Amendment reiteration of due process, as well as the Equal Protection Clause of the 14th Amendment. Whitmer repeatedly has shown that she doesn't care about those most fundamental points of the U.S. Constitution. And while the Michigan Supreme Court didn't necessarily have to mention those points because Whitmer's actions and the 1945 EPGA are so clearly antagonistic to their state constitution, it would have been nice to see the court engage that very important U.S. level of jurisprudential inquiry. Well, then again, it gives us a chance to do it ourselves, I suppose. And thanks to this ruling, we can research this ourselves and tell our friends and loved ones about how this case has a bearing on all our lives, whether we're inside Michigan or outside Michigan. We can pay attention to the actual rules, which evidently some politicians like Whitmer really would rather not have people do. You know, this kind of learning I think is pretty valuable. It's a dark time, but we can try to find some silver linings in those dark clouds, especially at a time when politicians like Whitmer continue to act like predators, absolutely hungry for power. Thanks so much for joining me, everyone, and best of luck to you in Michigan if you are out there struggling for freedom, or whatever state might be your home. And thanks also for all the great communication on YouTube. Remember, if you're watching on YouTube, please make sure that you're still subscribed, because sometimes people drop off the subscription list. Please like the videos and share them as much as possible, and head over to MRCTV.org. That's MRCTV.org to check out what the whole team is doing. I'll see you inside YouTube. We'll see you on Facebook. We'll see you on Instagram. And don't forget, if you want some great MRC items, it's MRC-store. That's MRC-store. For MRC TV, I'm Gardner Goldsmith.